Something that I just had an interesting experience with yesterday, talking to some folks from public utility districts, is an interest by public utility districts to bring some more enhanced sanity to rural water supply. And that would be through mechanisms of trying to get exempt wells grouped together under single water rights that would be professionally managed. It would be a lot safer way of providing water to folks, and it would be under a voluntary basis. So we're going to be talking with them some more about possible statutory changes that might allow for an existing law that allows for consolidation of exempt wells. With some changes in that statute, we might be able to influence more folks to use that provision on this. But the western states, California, Oregon, and Washington, have been pretty forward-looking on climate change, have been doing things like clean car legislation to try to reduce the amount of carbon dioxide and other greenhouse gases emitted in our states, stationary power sources as well, putting better controls on those. Our interest in this is that climate change promises to bring some very significant changes to the pattern of flow in rivers and streams, especially our rivers and streams that come out of mountains and are fed by snowpack. Because climate change means warmer winters, it means more rain in the winter and less snow accumulation. A lot of our rivers, like the Yakima Basin and a lot of the ones that feed the west side utilities over around Puget Sound, are dependent on snowpack. And what snowpack does is it absorbs a lot of water and holds it in the mountains and then releases it more slowly into the summer. And we've got water systems out there, including in the Yakima Basin, storage systems. We've got systems on the west side that have been designed around certain assumptions about when the water flow will come down. Well, if the water comes down earlier, if it comes down in greater quantities in the winter and less in the spring and summer, then we're going to see some pretty major disruption of some of the major water supply systems in the state. And this applies in this county as well, and in Clallam County. I'm highly concerned about what it may mean in the Dungeness Basin. This stuff is happening over decades, but there is evidence already that's been collected by the University of Washington Climate Impacts Group that shows that the amount of snow accumulating in the Cascade Mountains and in the Olympics has been on the decline since about 1950. And it really is quite dramatic. They are projecting that if nothing were done to reduce greenhouse gas emissions, you'd have temperature increases of 3 to 4 centigrade over a period of a century, and snow would become much more scarce in the Cascades and Olympics. And that would, in turn, as I indicated, mean some pretty amazing things for some of the water systems that we've built up. So we're working with the Climate Impacts Group. We're hoping to send some money their way here soon to refine some of the research that they're doing to bring the regional climate model down to a specific stream level so we can do some prediction about exactly what it means to the Dungeness River or to the Quilcene River in the future. Unfortunately, we had hoped to get some money in the governor's budget for doing some work on the west side of the state in that regard, but at this point, we're unsuccessful. So we're looking for partners, and I would beseech anybody here who's a utility manager or has an interest in this to talk to us about possibly doing some cost sharing. How do you find out whether your piece of land has a water right? Or I would add a claim or some other kind of document of a possible water right. There's several things you can do. First of all, look in your own files if you haven't already. If you have a deed, it may have some indication on it or in a document attached to it about whether there's a water right or a claim, because all water rights certificates, certainly since the beginning of the Water Code, have been required to be recorded with the county. And so county records is another place to go look. If that's more convenient to you than calling us or talking to us, and that's the third way. You can come to us or you can call us at our regional office, and someone there should be able to help you determine whether or not there's a water right on your property. Hopefully in the not too distant future, like within a couple of years, we're very hopeful that you'll be able to go to the internet and get this information off of our website. We have a project that was funded in the governor's budget to do exactly that, allow us to get all of our water rights data out on the internet where people can do their own research very simply through a map search technique, and you won't even have to talk to us unless you want to. There could be modifications. There's a lot of pressure to possibly modify. If you think about 1945, when there were maybe 2 million people in the state, we had a lot more elbow room, fewer people demanding water, certainly a lot less concern about fisheries and other things at that time. And in a lot of ways, I think it helped the department to have this exemption because of the 8,000 to 10,000 wells that are drilled every year that Joe mentioned, 95% of those do not come to us for a permit because they're in the exempt category. In my opinion, we could never handle that number of additional pieces of paper coming across our desk for a decision. But clearly the exemption is impacting existing water rights in some areas. It's clearly having an effect on stream flow in some areas, and so there is a pretty strong sentiment in some quarters at least to begin to put some additional limitations on the use of the exemption. One of our difficulties that's implied by this question is that we have no record of exempt withdrawals prior to, I believe it's 1967. It was in 1967 that the well drilling code was passed. I believe that's the year, it was the late 60s anyway, that required that a start card be, a notice of well drilling be provided to the department, and then after a well's drilled, a well report be given to the department. That's the only way we know of them in reality since 1967. Prior to that, there was no requirement to record them in any way, and so there are literally hundreds of thousands of them out there that we don't have any records of, even though we have, as Joe indicated, we've got 500,000 records. Those are records we don't have. So in order to find those would be quite a challenge. You'd have to send people out, probably do some correlation to parcels that are developed with county records. I'm not saying it couldn't be done, but it would be quite a project to find those old ones. We have pretty good, darn good records of the ones that have been put in since 1967, and in fact you can go on our website and you can do a well search and find literally hundreds of thousands of wells throughout the state and where those are located, and those are linked to the actual images of the well reports, and that has been a very useful tool, especially for drillers and for people interested in developing property. The general rule is if there's no other document associated with it, like severance of the water right from some parts of that land, then it basically, the default is that it's equally shared with let's say if it was subdivided into 10 pieces, then each of those resulting 10 pieces get a pro rata share based on the acreage. If it was being irrigated and only part of it was being irrigated, then that irrigation portion of that water right would only apply to those parcels that made up the former irrigated area. So it can get kind of complicated. Unfortunately, oftentimes when land is sold, there is no clear statement of exactly how the water is to be divided. And oftentimes, if it was irrigated before and now it's going to go to development, a PUD or a water system may provide the water, and they'll no longer use that water right, and after 5 years it would be terminated by relinquishment. I would say that if the use is going to be small, say a half an acre or maybe as much as 2 acres, you could conceivably irrigate that from an exempt well. As I said before, the Kim case kind of changed things a little bit. At least our interpretation is that an exemption can be used for commercial irrigation, but it is limited to 5,000 gallons per day maximum, even so. So in this area, I don't know how many acres you could irrigate with 5,000 gallons per day, but I'm guessing in the hottest part of summer, when the water demand is the highest, it might be a couple of acres. The preferred way, I would say, though, especially for a larger operation, would be to try to seek a water right to purchase and transfer to your location. And that's what a lot of folks are doing around the state right now. That's where most of our water right business is these days, is in approving those kinds of changes and transfers. There is a statute, as I mentioned before, that the PUDs are looking at pretty hard. It's, if you want to look it up, it's RCW 90.44.105, and it was passed in 1997, and it was in reaction exactly to that, that situation that you posed there, and that is that sometimes people may tire of maintaining their own well, their water quality may not be up to snuff, they may be concerned about health effects and that sort of thing, and we do find that some folks would be willing to give up their exempt well in exchange for a water supply, professionally managed water supply supplied by a PUD or a private water system or whatever. The law does allow for exempt wells in an area to be, by agreement of the landowners and the owners of those wells, to be consolidated onto an existing water right owned by a water supplier. And unfortunately, that last provision can be a limitation. There may not be a well in that same aquifer that's owned by a water supplier that's willing to take on the exempt uses. And that's one of the things I was talking with the PUDs about yesterday, is whether there's a way to allow those exempt wells to congeal in a different way rather than onto an existing water right, because we think that there's a need to do that in various parts of the state. Generally, there is a statute on this as well, the ability to replace a well or to add additional wells and avoid having to come to us for a water right change, but it can only be done if it's within the originally advertised area, the area where the public notice said the well was going to be located, and generally that's within a quarter section or a 40-acre parcel or 40-acre area. If you're going to move it outside that, which you may have to go further upland in a situation like that with saltwater intrusion, then you can come to us for a water right change, and those are not that difficult to get approved in a lot of cases, because we just have to determine that you're taking it from the same basic body of groundwater, which, if you're not moving it very far, would normally be the case. So if it's outside of the originally advertised location, and you can do that by consulting with us, or if you kept your paperwork from the original water right issuance, you should have an indication of what the public notice said, and then go from there. This is a common problem around the state with 170,000 water right claims out there, which are poorly, I mean, they're documented to the extent that the person put in a piece of paper and said, this is my water use, and this is when it began, and this is where the water is being used. Nobody has checked on those facts. And so it exists as the potential that it's a water right exists, but it isn't necessarily a water right. Let's say the person's use began in 1920 instead, and if it were ever brought to court and they couldn't provide evidence that it was used prior to 1917, it may not be a valid claim. And I can tell you that if as you look down the list of claims for any area of the state, you can find flaws all over the place in them. You know, use after 1917 for surface water use after 1945. Beginning of use, I should say, after those dates. Or in a lot of cases, claims, or at least some cases, claims say, I'm claiming this for future use. Well, that wasn't the purpose of the claims registration. It was really to identify whose water rights or potential water rights began before those dates. It can be done, Catherine, it takes some effort, with a fairly thorough research into each of those to see just what the history is. And short of a water right adjudication, and Fred can maybe talk about this a little later because he's very experienced at this, you can make assessments of what looks like good paper versus bad paper, and then you can kind of compare it to what's going on the ground. If it claims irrigation of a couple of acres, you know, you can use aerial photos or survey to see if that's really going on there. Is there really a house or not? Maybe the house burned down and since 1967, and it's no longer being used. So there's every possible fact pattern. A water right adjudication would be the ultimate way of turning claims, at least the valid ones, into water rights. And it's not a process that a lot of people want to get into because it takes a long time, it's fairly expensive, certainly uses a lot of state resources, and there's winners and there's losers. It really does reveal the history of every water right claim and who really has water and who really doesn't. But I can tell you that at the end of one, you have a lot more certainty about the water rights, and it makes the water rights much more transferable than they would have been before when they were surrounded by all that uncertainty. Not all federal land has reserved rights, but federal land that was set aside for a specific purpose generally will have a so-called reserved right. This is not a new doctrine. This dates back to a case in 1908, and that's why it's called the Winters Doctrine. The Winters case from the Milk River in Montana basically found that when Congress specifically set aside a piece of federal land for a specific purpose, like an Indian reservation, like a national park, like a fish and wildlife sanctuary or whatever, military reservation, it by implication also reserves sufficient water for that purpose. And quantifying those amounts is very difficult and generally requires an adjudication of that right in a state adjudication process. They can go to federal court and be adjudicated there as well, but that's more rare. They do cast a very long shadow over state-issued water rights. If you've got large amounts of federal land, Forest Service land, national park land, Indian reservations in your basin, then it's something that we all need to take into account. The state from 1917 on really has not taken into account that possibility. We have issued lots of state-issued water rights, or issued a lot of state water rights based on state law without taking that into account. And at some point, there will be a reckoning. Every Western state has done this. Most other Western states are much advanced beyond us in getting those water rights quantified and determined. And we will be, at some point, I think, having to do that. It's just inevitable. There have been bills to set up water courts in the state. Right now, appeals of ecology decisions go to the Pollution Control Hearings Board as the original venue, and then they can be appealed into the courts, the superior courts, and on up from there. Water right adjudications occur in Superior Court, which each county has a Superior Court. This notion would be to set up a specialized court that would deal with water appeals and water adjudications. And that proposal came forward 2 or 3 years ago. I helped write the bill, but it has not had gotten a whole lot of currency because of the cost. It costs a lot to set up a new court system, hire new judges and staff and courtrooms and the whole 9 yards. But the idea was, I think that if the state was going to enter a process to really adjudicate most or all of the water rights in the state, you would probably need something like that, a specialized court. Idaho has one, for example. They're doing virtually a statewide adjudication, and some other states do too, so that you kind of keep that out of the normal court system. Unfortunately, in this state, it would require a constitutional amendment to do that, to set up a new court, it would appear.